sucker out with that hand on top of your head. Doesn't understand you made it.
Yeah, I talked about how this guy Smith, he gotten stopped there, and he was in the parking lot there at Safeway, and they bashed down his windows, and then they arrested him, threw him in jail. Right? So I go, okay, and that happened. So the cop there, that sergeant there, he thought he didn't have a warrant. There wasn't any reasonable suspicion according to the court. And they just didn't have a right to bash the guy's window down. So I'm going to show you here the actual result of what happened. And now you've seen the video. Let's check it out. All right. So yeah, here's the docket. It was People versus Smith. See that where it says case dismissed. Now, how did that even happen? Why is this case dismissed? They had a right. They bashed down his window there. He was, they charged him with resisting arrest. He was resisting because he was sitting there in his car in the parking lot and remaining silent. That's what he was doing. He was just remaining silent there in the car. And he said, sorry, I'm going to remain silent. I'm going to exercise my right to remain silent and not going to answer any questions. And then they smashed his window down. So now here's the case. They dismissed it. Now there's a ruling. He went to trial. It happened pretty fast. He was having his trial here, misdemeanor jury trial, document filed. He got the oath of the judge, and it doesn't really say here what happened. Okay. But I know that he filed a 1538.5 motion. Okay, that was for sure what was being heard. Now, there it is. PC 1538.5 motion. I know that he filed that. Okay, and that's what was being heard. And they kept continuing it at trial. Motion to suppress the evidence because it was obtained without a warrant. So here was here's the document that they gave him. It says Smith 21. This is on July 16th. Okay, and it says 10:49 a.m. Jury trial day 3, making a record. Case pursuant to dismissed pursuant to 1385. So they said right there it was 1385. 1385 says dismissal of action for want of prosecution. The judge or magistrate may, on either motion of the court or on application of the prosecuting attorney and the furtherance of justice, order an action to be dismissed for the reasons of the dismissal stated herein orally on the record. The court shall state the reasons of the dismissal in the minutes, and if requested by either party in the case in which proceedings are not recorded electronically or recorded by a court reporter, the dismissal shall not be made for any other cause that will be grounds for demur in the accusatory pleadings. All right, so there he goes. In his car. He was resisting. This cop said he was resisting arrest. Guess who said he wasn't? The judge.
All of your body cam.
So the judge says, no, pal. No.
You were the one that doesn't entirely go around helping. I did absolutely nothing.
Cop, you're not allowed to just bust down people's windows on the side of the road at a Safeway parking lot like that with no warrant and no reasonable suspicion. That's what happened. He had no reasonable suspicion. He had no warrant and no grounds to arrest. Forget arrest. To bash down someone's violently smash in and break in like a goon into someone's car. Imagine if someone did that to you. Do you think that's fair? I love cops. I am all about law enforcement, and I follow the law to the letter of the law. I'm very passionate about it. But when they don't, I have a problem with that. Now, what they say, well, we have some sort of a vehicle code that's okay, and we have kind of our discretion. They have no discretion. They don't have discretion. Discretion's for a judge, not a cop. Cop is an executive power, not a judicial power. And they're abusing their ministerial function by going outside the Fourth Amendment of the Constitution, which says right to remain peacefully in your vehicle, your persons, places, things, without somebody bashing down your windows without a warrant or suspicion of a crime. Like maybe if they smelled drugs or booze in the car, that would be potential reasonable suspicion. He was recklessly driving on the freeway and weaving in and out of traffic, causing danger, hollering at people, looting. Those things, yeah, okay. Okay, if the cop saw all that and that was alleged in the complaint, this case would have not been dismissed. It would have been going forward, but none of that was in the complaint. All the complaint said was Smith resisted arrest. He was resisting. That's not what the judge said. That didn't look like any resisting to me. There's another clip here I'll show here at the end. It's shoot, the next morning, and I'm like, what happened to my buddy? And I'm like, he sure, sometimes he goes offline. I was like, man, something happened. I said, just was like, but he called me while it was happening, and I'm like, oh man, are you having a problem there? He's like, yeah, something's going on. The cops showed up. I was like, well, just don't get crazy, don't get out of control. And then after that, his phone went dead, and I thought, oh man, something happened. So he got arrested. Calls me the next day from one of those numbers where they call you from jail. It's a collect call. Oh, it's the funny number. What do they say? Put 50 cents in to make this call. You get all the things. So I get that call. I'm like, hey man, what's up? He said, oh yeah, I'm gonna be out soon. Okay. It was speedy trial was everything. They kept reminding him, DA. So he didn't wait time. The 45-day clock starts. Immediately, he requests discovery under 15. Oh, it's 15. I don't know what the discovery statute is, but you can request. They have to give you the discovery, all the discovery when you request it in writing. One time, you don't have to keep going in there and ask him, hey, please give me the discovery. They're supposed to give it to you, and they're supposed to give it to you right away. So he requested it right when he pled in writing. They made excuses, said they didn't get it. Oh, we don't do that. All these excuses. Finally, it was over 40, like 35 days, 40 days later. It was June 27th. So he pled on, it was June, anyways, 45 days before Monday. So whatever that was, that would have been late May. He pled. By June 30th, they finally give him discovery, June 27th. And in the discovery, it's all the body camera footage. And in the body camera footage, it's all cut up and it's muted. And then they didn't provide some of the documents that he asked for, like the oath of office. Now, he really likes the oath of office. He believes that's a big deal. And I do too, and it is a big deal. But I don't know if they're required to give that in discovery. But so they didn't give that. So that set up a potential motion, a discovery motion. But rather than do that, he did a 1538.5 motion to suppress all the evidence before the court. All right, so the 1538.5 motion under the Penal Code, what it says is that you can motion the court to suppress the evidence that they attained because they didn't have a warrant and they didn't have reasonable suspicion. Or if they had a warrant, it was unreasonable, it was invalid. These are just grounds for the motion, either a bad warrant or no warrant at all and no reasonable suspicion. Now, there's a quagmire there with reasonable suspicion and probable cause. So I'm just going to go off the statute, not off theory. I'm a statute guy. So if you're a legal theory guy and you go off of these common law principles, that people argue about this and I'm not that guy. So maybe like the old school common law principle. Arrest him in the first place. Why? Because it wasn't even in the complaint. So inside the complaint, all they said was he was resisting arrest. So he's resisting arrest and they bashed down his window. I mean, that literally, there was not a fact in the complaint. It was one sentence. You're charged with resisting arrest and you're charged with not having a driver's license. Well, how did you get to that point, sir? Well, they didn't say. And none of the body camera footage even showed how they got to that point. So he's like, screw that. We're gonna do a motion to suppress all that because they definitely didn't have a warrant, and there's no reasonable suspicion to do any of this stuff. So that goes in. Now they kept delaying one day after another. It was like they would delay on freaking, I think they delayed on Friday. We'll delay the motion to suppress another day. Then they delayed it again. Counsel made excuses. They delayed it like 5 or 6 times. They would continue it. Finally, the last day was Monday, a week ago. And they said, that's the 45th day. And counsel over the weekend, last weekend, I think I remember on the call last time, I don't know if it was last Saturday, if I told you about this, Catherine, if it was Sunday, but the counsel, the district attorney of Richmond, he sent actually his assistant, another deputy district attorney. She sends an email over to the court on Friday afternoon saying ex parte communication to the judge. Hey, judge, we really, really need you to set this trial for Monday, please. It's super important. That's our last day. We can't have any more continuances. And the judge's clerk responds back, and Smith gets a copy of it, and it says, you're not allowed to have ex parte communication about subject matter. You can contact the court about scheduling, like that's what it says in the rules. Sure, scheduling motions, like, calendaring things, that's fine. But you can't argue and ask favors with the clerk and court ex parte. Hey, please help me out by doing this and that. That's absolutely a violation of the judicial canons, and the judge reprimanded counsel. So he put in a 1211 declaration on that district attorney and asked for, an order to show cause for why they shouldn't be held in contempt. It's preliminary hearing. If you remember on Perry Mason back in the day, they would have the preliminary hearing. They would always have everybody come in and they would say, hey, let's see if we have enough evidence to charge this guy with a crime. And they would bring in the witnesses and they would, try to flush them all out. That wasn't the guy's trial. If you watch Perry Mason, that actually wasn't the trial. That was the preliminary hearing.
Right. Yeah, correct. Yeah. TV showed us. Yeah.
Mm-hmm. So that was just a preliminary hearing, but they don't do that anymore. And I'm still unclear as to where and when in history that went away, or where it's authorized or not authorized by the Constitution.
Okay, Gavin, can I say something?
Yeah.
Okay, it's in our penal codes that you don't get for misdemeanors, you don't get a preliminary hearing anymore.
Okay.
I can't remember what the penal code is, but I remember reading it.
They got rid of it.
Yeah.
Yeah. Which okay, so it's legislative. They've eliminated it, and it is what it is. So that was always a problem for me, but now I see that the motion to suppress it causes the preliminary hearing. That's what it does, because it was just I just had never witnessed it and seen how it went. What it did though is I thought it would be before trial. Oh, it'll be before trial. No, it wasn't that way. It has to be in writing, and you got to put it in really 10 days before, and then at trial they scheduled a preliminary hearing. That's what the hearing is on the motion to suppress. Okay, counsel, here's your chance. And so what the judge did is she said, all right, we're going to have the 1538.5 motion. That's what they call it. It's a preliminary hearing. We're going to have the hearing. Counsel, bring in your witnesses, whoever you want. And that's when counsel started making all these excuses. Oh, my witnesses are busy. We need more time. Well, all right, we'll give you more time tomorrow. Let's come back. So they come back tomorrow, same thing. He gives the same excuse. Oh, everybody's busy, Judge. I need more time. All right, one more day. Wednesday, come back again. And really, we're past the 45 days now because they already continued twice now. That really is improper right there. Now here we are on Wednesday, and again, same thing in the morning. Counsel makes more excuses. Oh, I'm not ready. Finally, the judge says, listen, counsel, that's 3 times now you're not ready. Now, you told me you were ready on Friday and Monday. You were ready to go. Let's do it. Defense is ready. You're not ready. I'm giving you till 1:30. You got 100 people outside, counsel, in the jury waiting for you. So you come back at 1:30. You get your case ready. Whoever you need, you got to be here. He's like, I'll bring in a witness, and he tried to bring in a hearsay witness, somebody who was not the arresting officer. And then Smith objected. He's like, I'm going to object, counsel, because that's a hearsay witness. They weren't even there. I don't know why counsel's trying to bring them in. And then the judge is like, counsel, you want to bring in who? Oh, it's so-and-so, officer so-and-so. And were they the person that wrote the report? Well, no. Well, were they there? Oh, yeah, they came later on. They were there. Well, But did they arrest Smith? No, they didn't stop him or arrest. I was like, well, then that's not a, no, we can't hear from that person. That they can't establish probable, reasonable suspicion. They didn't even do it. They didn't even see Smith, so that's not even a valid witness. We need the other witness. He's like, okay. So finally, he comes back at 1:30 and I come in, I'm a little late. Smith calls me and I stopped going into court because they kept continuing so many times. And he calls me, he's like, okay, they're going to have it this time. And so it's 1:36. I finally get down there 6 minutes late. And I was like, listening in. And then the judge is like saying, is there, and she's just giving counsel, the tongue lashing of his life, and it's like, well, counsel, you've had through all this time to get your case ready. You brought this case. This is your case, and you're not ready again. And so this is extremely bad faith on your part. Oh, but judge, this is what I'm hearing. Literally, he said there, but judge, it's going to work out. I just need more time. I promise. I'm gonna get this case together. Please. You've had so much time to get this. We're past 45 days. He didn't waive his time. I got 35 cases behind you in the courtroom right now. You see all these people. There's a packed courtroom and 100 jurors outside, all ready to. They're selecting everybody, and you here are not ready to go. He's like, I'm going to dismiss this case, counsel. 1385 allows a judge to dismiss a case on her own, discretion when the counsel can't get his case together. And so she's like, I'm dismissing. Counsel begged and pleaded more. And he's like, I just need a little more time, and tried to. He's like, counsel, I dismissed the case. It's over. He's 22 years old, district attorney, Richmond. Yeah, deputy district attorney, not the lead, but he's a 22-year-old kid. And every time there was a case, everybody would plead no contest or not guilty. So I noticed that sat in there for all these continuances, and that's what would happen. One after another. It would always be illegal aliens too. One after another. It was only a few Americans that were even there to be in cases. It was all DUIs, illegals on DUIs, pretty much every case. They would do no contest or guilty. So counsel wins every time. He wins every time. And so he loses this case. He storms out of the courtroom and I chase him out. I start chasing him down. I said, wait, counsel, wait a second, because I want to talk to you. And he runs out, slams the door to his office. I follow him in there, and it's still unlocked. I open the door, and I say, I need to talk to Sean, the district attorney. And he says, and they say, oh, he's not feeling well. He's throwing up right. I said, oh, I bet he's not feeling well. He's throwing up in a trash can. Okay, well, I bet after that tongue lashing he took from the judge and the embarrassment of the whole court. Of course, So they send out the manager, and I said, listen, I said, my buddy Smith here just won his case, and I said, I want to talk in private. We got a lot of people here. I don't think it's proper to talk about all this stuff in front of everybody in this office here. So if you could set a meeting. And she's like, yeah, I can do it. So we set a meeting for Monday at 11, and we're going to do it in private, and we're just going to. So that's the overview, the preview. Smith won his case. They didn't have reasonable suspicion. Definitely no probable cause. So there's no warrant. And all those shenanigans, all that danger, all the emergency that was created by that deputy, by that sergeant. And I got to call out that arrogant sergeant because I read some emails from him, and he had the audacity to go to the district attorney in private and say, and talk bad about Smith and say that, Smith's going to lose. He's got no case, giving legal advice to the district attorney. And he disclosed that to Smith. I saw that. Smith told me about it. And I said, wow. Audacity. So now that sergeant was wrong. Not because I said so, not because Smith said so, just because the judge said so. He was wrong. He had no reasonable suspicion. He had no warrant. He had no right to break into someone's car in the middle of a Safeway parking lot just because he's got a badge on him like that. Oh, I'm wearing a badge. I'm going to break into your car. That's not allowed under our laws. Under our Constitution. As an American, we got a flag outside there. You see that flag, Sergeant? That's an American flag. And under our American flag, we've got something called constitutional protections. Not everybody has the ability to enforce their constitutional protections. Smith, hats off, he did. He enforced his constitutional protections. He has them. And he was right. He won. That's badass. So hats off to him. And, a little update. If you like the video, hit the ones. My name is Gavin Mehl. Definitely a disclaimer. None of this is legal advice. I am definitely not an attorney, but I'm always a concerned American, supporting other Americans who believe in freedom and liberty. And we all have that right. So never think that knowing the law, learning the law, or learning how to protect your own rights is some way a bad idea, because that's always been our provisions for the last 250 years. It's only been recently in our recent history that that's been forgotten. All right, so hit the ones. My name is Gavin. I'll see you at the top.